Okay, so good afternoon, everybody. Welcome back and thank you for joining us for week 7 of 10. We're more than halfway through our training series and we will have 3 more following this one. My name is Denise Nerby. I was born and raised here in Bethel. My parents are Barbara and Carl Anvil Sr. I'm the manager for the AVCP Tribal Justice Department. I hope everybody is staying warm and staying safe as we're coming up on Thanksgiving. It's just, I don't know, I love to eat, so I'm excited for Thanksgiving. Anyways, so as always, starting with our housekeeping reminder, these trainings are being recorded and we're all placed on mute to begin with. We ask that you remain muted unless speaking, and to unmute yourself on the phone, press *6, or on the computer, there's a little microphone button at the top right-hand area of your screen. At this point in our training series, many of you have heard from our presenters before. Today, you will hear from Kevin Illingworth, Rick Garcia, Judge Deborah O'Gara, Winter Montgomery, and myself. We're going to be speaking toward the topic of ICWA. Before I hand the time over to Rick, I just want to encourage everyone to ask or state any questions or comments that you might have. We really encourage any dialogue. If you're online, you can drop these questions into the chat and we'll get those answered for you as well. So without further hesitation, I am going to hand the time over to you, Rick.
Thanks, Denise. Can everybody hear me okay? Okay.
Yes.
Well, good afternoon, everyone. It's so great to see so many familiar faces and to hear so many familiar voices. I want to first thank Denise and her wonderful Tribal Justice Department staff for inviting me and my co-presenters to present today. And I also really just want to recognize and thank them for the wonderful work they are doing in the YK region. I think that I know everybody on the call, but for those who don't know me, my name is Rick Garcia. I am a tribal court facilitator with the Alaska Native Justice Center here in Anchorage. I'm originally from Miami, Florida, although I've been living in Alaska for almost 4 years now. I'm an attorney by trade. And before my employment with ANJC, I had the privilege of serving as a district court magistrate judge for the Alaska court system in Aniak and Hooper Bay. And also had the wonderful honor of working with AVCP as their Associate General Counsel and Tribal Justice Director. So I'm excited to be here today. AVCP and the AVCP tribes really hold a very special place in my heart. And so I'm excited and thankful to be presenting today and to really share this important conversation with you all. As Denise mentioned, I am going to be co-presenting with Judge Deborah O'Gara, Kevin Illingworth, and Winter Montgomery. And at this time, I want to give them an opportunity to introduce themselves before we move on with the presentation. I'll start with Deborah.
It was like we were all wondering who's going to go next. So I think, like Rick has already said, I think everybody has seen or heard from us already. I'm Deborah O'Gara. My Tlingit name is Tjuksuk. I'm actually calling in from very close to my ancestral home, but not quite. So I'm calling in from Petersburg, Alaska, which is down in southeast Alaska, of the southeast part of the state. I have been practicing law for the last 31 years, and about half of that has been in a judicial role of some kind, mostly in tribal courts. And one of my favorite areas is the YK Delta. My mom was born and raised up in Mountain Village. So every time I have an opportunity to meet with a group of folks who are doing stuff that I'm very passionate about, I jump at the chance. So I'm very honored and happy to be here.
Awesome, thanks, Deborah. And how about Kevin?
Hey, good afternoon, everybody. Kevin Illingworth, and I think I have met most of you before. I'm a professor of tribal governance at UAF, and I'm located in Fairbanks here at the Trothiadoc campus. I'm happy to be here. Thanks.
Thanks, Kevin. And Winter.
Hi, everyone. I'm Winter Montgomery. I'm the Tribal Justice Attorney. I'm also in the Air Force. I'm a Judge Advocate General in the Air Force. My passions are tribal law and veterans law. But prior to this, and relevant to this presentation, I did public defense for 8 years prior to being the tribal justice attorney here at ABCP. So I represented parents and child in need of aid proceedings. 100% of my cases involved ICWA. So today, I'm happy to be part of the presentation, and I hope I can draw on some of that experience. Thanks.
Awesome. Thanks, Spencer. And I just kind of want to reiterate what Denise had said. Throughout the presentation, if anyone has any questions, please go ahead and ask those questions in the chat, or please feel free to unmute yourselves, interrupt me, tell me to stop, and ask those questions. I've always found that the best trainings for me are the ones that are interactive between the presenter and the people who are participating in that. And then also that if you have a question, there's a really good chance that someone else listening has that same question. So please ask away. All of the co-presenters today are happy to answer any questions that we can. Next slide, please. So we always like to start presentations by really talking about what we hope the presentation will cover. Today we are going to be talking about ICWA, and specifically we're going to be talking about what is the Indian Child Welfare Act, or ICWA. Why was ICWA needed? When does ICWA apply? We're going to be sharing a little bit about who is an Indian child under the ICWA. And then we're going to move in and talk about procedural and substantive rights under ICWA. And then we're going to draw a corollary between ICWA cases and Alaska-China cases. And then finally, we're going to talk about tribal child protection cases and whether or not ICWA applies in those types of cases. Next slide, please. So, of course, the first thing is, what is the Indian Child Welfare Act? Well, the Indian Child Welfare Act, and I'm going to just refer to it as ICWA, like we all know it, of 1978, it was a federal law, or it is a federal law, that really governs the removal and out-of-home placement of Alaska Native and Native American children. The law was enacted after recognition by the federal government that American Indian children were being removed from their homes and communities at a much higher rate than non-Native children. And so some of the things that precipitated the passing of ICWA was something called the adoption era. And so during the adoption era, which was a federal program that was administered then by the Child Welfare League of America and funded by the Bureau of Indian Affairs, was conducted between 1958 through 1967. And that program resulted in 35% of all Native American children being forcibly removed from their homes and adopted into white families. Many Alaska Native American Indian children were systematically removed from their home based on really tenuous allegations and placed in non-Indian homes and adopted. During this time, states were also paid by the BIA to remove Indian children from their homes. So when we talk about the adoption era, I think it's important to highlight those tenuous allegations. And so we have some examples of what the allegations were that helped to remove the Alaska Native and American Indian children from their homes. Some of the factors that were considered and were stated that there was a lack of electricity, there was a lack of Western education, that Alaska Native and American Indian children were non-conforming to Western beliefs. They also had a systematic way of using Western class, white middle class status to really judge the quality of life of American Indian and Alaska Native children and families. Of course, we know there were cultural biases regarding child upbringing were used as justification for removal. And so what resulted after the adoption era was really the passage of ICWA, which is considered in the child welfare world as the gold standard in tribal child welfare. And what it did is it established standards for the placement of Indian children in foster and adoptive homes, and really enabled tribes and families to be involved in child welfare cases. ICWA is a response to hundreds of years of cultural matters recognizing tribal jurisdiction over matters of child custody and families. And so before we move on to the next slide, I think it's important to really talk about the ICWA stated policy. And so the policy of ICWA, which is in the ICWA law, the Congress declared that it is the policy of this nation to protect the best interests of Indian children and to promote the stability and security of Indian tribes and Indian families by the establishment of minimum federal standards to prevent the arbitrary removal of Indian children from their families and tribes, and to ensure that measures would prevent the breakup of Indian families and are followed in child custody proceedings. So that's a lot of words to really say that the United States recognized that the adoption era policies and how they were being applied to Indian children were not working, and that they were reducing it, and they're trying to enact law to really combat what had happened previously. Next slide, please. And I'm going to pass it over to Kevin to talk about why ICWA was needed.
Yeah, thanks, Rick. You know, hearing you talk about the adoption era, it really makes my heart heavy, because I feel like so much of this is still happening in Alaska today. This is so much a part of all of our shared history. Of course, it goes without saying that the Indian Child Welfare Act, of course, also applies to all of our Native children here in Alaska, and this exact same history that we're talking about happened here in Alaska and continues to happen today. The slide of why the Indian Child Welfare Act was needed. I really think Rick did a great job in talking about the adoption era, and the removal rates here listed 25 to 35% of Native children being removed from their homes was actually much higher in some regions of the United States. This is of all the children in the whole entire United States, but we know that most tribes are located in just a few states like Alaska or other places. I really want to talk for a second, though, and I really want to recognize the impact on children and the importance of the Indian Child Welfare Act in that sense. And some of you have heard me talk about this before. ICWA, to me, is one of the most important laws ever passed, and it's very personal. My older sister was adopted, taken away from her tribe, from her community and her family before the passage of the Indian Child Welfare Act. She was taken by the North Dakota Department of Social Services and adopted to my parents, specifically because my dad was in the Air Force. This was actually a widespread plan we saw across the United States, particularly here in Alaska as well, where Native children were adopted to military families. Because the state of North Dakota knew that within 1 year after my sister was adopted, my dad was transferred. Until my sister was 35 years old, she never stepped foot in North Dakota again. She never saw her family, she never saw her people. She was never a part of her culture. We would lie on the floor in the living room and read an encyclopedia about Hidatsa Indians so that my sister could learn about who her people were. We grew up in the same house and living completely parallel lives in how I was treated as a entitled, blonde-haired white child and how she was treated as a brown-skinned Native child. She struggled to find who she was her whole life. I've talked about this before, and I'm very happy to say that she's found peace with herself. She's found who her mother is. She actually found out who her father's family was, and so much about herself by going back to her community, to her reservation. But it was so traumatic for her to have to do. And I really want to recognize that this happened here in Alaska and continues to happen. Actually, one of the most devastating stories I've ever heard about children being adopted outside of their home, outside of their culture, comes from Yupik country here in Alaska, and it was a story printed in the Tundra Drums. Some of you might remember this. I apologize. I looked for the article, and Tundra Drums doesn't have a good website of their past articles anymore. But it was these two Yupik children, a boy and a girl, that were adopted to an Air Force family stationed at Eielson Air Force Base here in Fairbanks. They were removed from their homes very young. The older boy was 5 when he was removed. The family left Alaska, left the Air Force, and ended emigrating to Israel. They were a Jewish family, and of course they took the children with them. This article was about the fact that this in the country of Israel, you have to mandatorily serve in the military, and this girl was going to serve in the military for her 2 years. And she was being interviewed about the fact that she was Yupik and from Alaska, but had never seen snow. And her story was about how she hoped she makes it through this war that she was going to be sent to so that someday she could go visit Alaska and see snow. And it's heart-wrenching, right? It's just heartbreaking. I'm crying right now because of this trauma that's been perpetrated upon this child, upon this family, that we're all having to deal with. So this, to me, is the reason why the Indian Child Welfare Act was passed. So people can stay a part of their family, a part of their culture, know who they are, and not have to deal with this trauma that so many children have had to work through. Thanks, Rick.
Thanks, Kevin. And next slide, please. And I think we're going to switch over to Winter.
All right. So when does ICWA apply? So the Indian Child Welfare Act applies when the government is taking action. So the main ways that your tribe probably sees this is through the child in need of aid cases, but there's other proceedings, if you want to put to the next slide, there's other proceedings where ICWA applies. So the one that you're most familiar with, where your tribe probably intervenes in state court action, would be the child in need of aid proceeding. And one of the important standards from ICWA in the China proceedings in a state court are the removal standard. So it's a lot higher standard to remove children, and that's because of, as Rick and Kevin just spoke of the high rate of Native children being taken away based on racism, based on so many other factors that weren't related to actually the care that they were receiving at home. So when I practiced as a representing parents to get their kids back, we would a lot of times be contesting at the first hearing, at the probable cause removal hearing. If the state had taken, OCS had taken the child, then we would get to cross-examine the witnesses and make a case to the judge that the children should not have been removed because the standard was very high, which the state had to prove that there was imminent physical harm to the child, or the state had to bring an expert to say that based on the care of the parents of this child, that there was going to be emotional damage to the child. So it's a very high standard, and it was a higher standard than when white children are taken from their home. So this is one of the biggest protections I saw in practice was the high standard for removal. And actually here in the Delta, they finally started filing more non-emergency petitions where they would seek custody, but keep the children in the home. But there was a time that there was just 100, it was just every single hearing was removal. And then we were winning some of the cases. So basically it was really traumatic for the children because you could walk out of the hearing, oh, we won, I guess, but the children had been, taken from their homes for 48 to 72 hours and put in random homes, sometimes not even together. And in an emergency basis, they're supposed to comply and put them with a Native family, but under the emergency situation, they just put them with any foster parent. So I always thought about that when, lawyers are like, oh, we won the case. I was like, well, I guess we won and the children were removed, but it was such a detrimental experience. And it's so important to have the high removal standards to protect Native children, but there's definitely mistakes that happen, but at least we can go to the court and fight for the children to be returned if the state can't prove that they have imminent danger, or an expert can't testify that by leaving them in the home, they're going to have emotional damage. So I just wanted to give an example of some of the how ICWA we see in China cases. The other proceedings are adoptions. I've only done one adoption in private practice. I ended up doing an adoption, and ICWA did apply in that adoption. It was under that circumstance a white family adopting a special needs Native child. They had been their foster parent for many years, but it was not a simple adoption because there had to be testimony, and we had to meet the standard for ICWA that there had to be good cause to deviate from the ICWA standards, which are really a strong preference for Native children to be with Native families. So that was an adoption that the court found that we had met those burdens, but other times that can't be met because the burdens are high to show that the child should be with a Native family. And in this case, I think the judge found the deviation because the family lived in the Delta. There was an open adoption. The child was still going to have contact with their community, with their biological parents, with siblings. And so there were other reasons, but ICWA does apply in adoptions, and there are standards that need to be met there for certain guardianships as well, like minor guardianships. If it's a Native child, there needs to be preference to Native family, and if not, then the good cause to deviate from that standard. And then in certain juvenile matters, ICWA can apply. I was trying to think, a lot of the juvenile cases that I had, I made arguments that ICWA should apply for some of the, when they put a child in detention and then we're putting them in a kind of like a community home with other juveniles. I tried to argue in one of my cases that there should be a preference for a Native family. That wasn't actually, the judge didn't agree with me on that. So there are some juvenile matters that ICWA does apply, but then there's other times that it doesn't. So in my case, I wasn't able to make that connection, but there are some dealing with removal of juveniles in the detention procedures that it would apply. Things where it doesn't apply would be the where it's private citizen versus another private citizen. That's not the government taking action. That's just like a divorce or custody. Those are just two individuals that have a dispute between each other. So that's not the government taking action. So ICWA doesn't apply in those private proceedings. All right, next slide, please. So who is an Indian child under ICWA? A lot of people will always say that it has to, some people say, oh, it's a member, an Indian child is a member of a tribe. It's actually eligible for membership. So let's say there's a child that is 6 months old. They've been removed from by the state, by OCS, and are being put in a different home. When you show up at that first hearing, and I've actually had the state say, well, they're not, ICWA doesn't apply because they're not enrolled. Whoa. So you can go back and just recite the law that it's someone that's eligible for membership. So if the parents are enrolled, but the child hasn't been enrolled yet, that's just a formality that hasn't been met, but they're eligible for enrollment, then ICWA applies just the same as if they have the card with their name on it. So it's important to know that distinction is that it doesn't matter if they're enrolled, as long as they're eligible for membership, ICWA will apply.
Very good. Thanks, Mintar. I think we're going to move to Deborah next. Next slide, please.
Okay, thanks. So I so much agree with everything that's been said so far. Children's cases, whether they're ICWA cases or child or custody cases, is never easy, and I don't think there's rarely any wins in that, because whenever there's an ICWA case, it means that there's been some kind of neglect or abuse that has occurred, or at least it's suspected to have occurred. And the nice thing about, just to follow up with what Winter just said, the nice thing about the definition of who is an Indian child under ICWA is that it is up to the tribe that that child is eligible for enrollment in that determines whether they are a quote Indian child or not. It's not up to the state or the federal government. It's really up to the tribe to determine who are their members or citizens, and who is eligible for enrollment. So you always have to go back to that tribe. There's also this magic word, or this magic 3 words in the ICWA Act, child custody proceeding. And in order for ICWA to actually apply to a children's case in the state courts, there must first be a child custody proceeding. And again, there's a whole definition for that. And what it means is that the child has been removed from their home, or restrictions have been put on the placement of that child by the state. And that placement can't be changed voluntarily without the state saying yay or nay. So in other words, if the child has been removed and placed by court order with a foster parent or even a relative, and the courts have said this is the placement, and the parents are not allowed to go into grandma or grandpa's home or aunt and uncle's home and retrieve the child, bring the child home, then it is a child custody proceeding under ICWA. And with that definition, that's how Winter was able to actually make an argument that ICWA applied when a juvenile, for instance, is placed in a group home. Now, it may be based on a lot of different things that have happened, but it has in some places been argued that, yes, ICWA applies. Where it doesn't apply is in the custody matters. And if there is nowhere in the case where the state has taken any action, and the state in this state is the Office of Children's Services and the state court, if there's been nothing, no action taken by the Office of Children's Services, it is likely not an ICWA case, or at least not yet. Often parents who are having to come up with a custody decision or custody order, they do go to state court for that, but that alone does not mean that it is a ICWA case. And the reason why it's important to know whether it's an ICWA case or just a custody case is that if it's a custody case, some of the provisions like placement preferences do not apply in a custody matter. It's really just a dispute between two parents. And that happens a lot, and the confusion is very valid because children are children are children. And whenever there's children, we want to protect that child's connection to their tribe and the tribe's interest in protecting the children. But if it's a dispute between two parents, the tribe doesn't have an interest, and the state that also doesn't have an interest. So I hope that's clear as mud, because it really is, it does get very confusing, and is really the source of a lot of confusion. So it's important to see, really, for here in Alaska, ask if the Office of Children's Services is involved, and if they're not, it's likely not it's likely not an ICWA case. Not always, but likely. So that's your first indication. Next slide. I think it goes to over to Denise.
Thanks, Deborah. So listed on this slide are child abuse triggers that initiate a China case in court. So listed 1 through 12 are abandonment. A parent is incarcerated and the other parent has committed abuse. A custodian can no longer care for the child and the parent is missing. A parent fails to provide medical treatment. The child refuses to stay home. Physical abuse, sexual abuse, domestic violence, including mental injury to the children, neglect, substance abuse, mental illness of a parent, and if the parent encourages a child to commit a crime. So these are some things under Alaska Statute 47.10.011, if you want to be really technical, but there are some of the actions that trigger China cases in courts. Next slide.
Awesome. Thanks, Denise. So I know that we have gone through a lot of information, a lot of technical information. So I just want to pause for a second to see if anybody has any questions before we move on and give you more technical information.
I don't have a
Okay.
question,
Yeah.
but I just want to clarify. I did remember something about that juvenile case. So I argued that ICWA applied because they were placing the Native child in this white group home, away from their culture and family. But I remember the reason that the ICWA didn't apply was because it was the state didn't actually have custody, but the parents were placing there, but it was basically at the direction of the state. So even though I made the argument, it was basically the state action, but it was just through the parents' directive. The court still said, well, the parents are the ones that have custody. They're the ones placing them. So in that case, well, the parents can place their child. They have the authority to put their child anywhere when they're under 18, send them to the youth facility, like the military youth facility, or put them in this group home. But my argument was basically they were getting pushed to it by the state, but it was just kind of cloaked as under something else. So that's why. So it does apply. But the state has to have custody. So that was the distinction. I was wondering, I was like, I can't remember what it was, but yeah, sitting here, that was the issue.
Yeah, thanks, Winter. I think that's a very good illustration of the distinction that there must be some state action in order for ICWA to apply. So when we're talking about ICWA, there are two sections that I want to highlight. There's a procedural requirements section and there's a substantive rights section. And so we'll go through in the next two slides talking about that. I want to explain what procedural rights are first. Procedural rights really just mandate they're mandatory formal steps that must be taken in enforcing some type of legal rights. So when we talk about procedural rights in ICWA, they're designed to really ensure that tribes can intervene as a legal party in the China case in state courts. Many of these rights are designed to ensure that the tribes receive the same rights and access to information related to the case as other parties in the case, and that they also have the right to challenge decisions made by other parties, including challenging the state on not following any procedural rights or requirements of ICWA itself in the proceedings. So when we talk about procedural requirements, again, we're talking about formal steps that are required. There are notice requirements. It's a tribe's right to intervene, a right to counsel at government expense, and we're going to talk a little bit more about who that right to counsel applies to. Parties have the right to examine reports, talking about standards of proof and expert witnesses' testimony, and then rights to challenge ICWA violation. Next slide, please. So when we talk about substantive rights are rights and obligations of individuals or parties, including the tribe, and those rights are established by law. So in this case, we're going to really talk about and focus on active efforts because we hear a lot of that, the terms floating around active efforts. And so under ICWA, active efforts means they are affirmative, active, thorough, and timely efforts that are taken by the state intended to maintain or reunite an Indian child with his or her family. So going back to what Deb, Kevin, and Winter have talked about, when there is a state action involved and there's a state taking, where an agency, which again in Alaska is the Office of Children's Services, is involved in child custody proceeding, active efforts must involve assisting the parent or parents or Indian custodians through the steps of a case plan and with accessing or developing the resources necessary to satisfy the case plan. It's important to also note that active efforts should be provided in a manner that is consistent with the social and cultural conditions and way of life of the Indian child tribe, and should really be conducted in partnership with the Indian child, the Indian child's parents, the extended family members, any Indian custodians, and also the tribe. This is an important sense because it not only requires that state agency partner with the parents, the family members, custodians, but they also really work with the tribe in providing those active efforts and those cultural connections and conditions that are culturally appropriate to the Indian child and their families. ICWA gives us some guidance on what may be considered active efforts, and I don't want to go through a lot of them. There are a few, but I think, again, some of the more important ones are identifying appropriate services and helping the parents to overcome barriers, including actively assisting the parents in obtaining culturally appropriate services. There are requirements of identifying, notifying, and inviting representatives of the Indian child tribe to participate in providing support and services to the child's family and in family team meetings, permanency planning, and resolution of placement issues. It also requires that their active efforts are defined to taking steps to keep siblings together whenever possible, which is really important, keeping our siblings together. And then, of course, considering alternative ways to address needs of Indian child's parents and where appropriate the family, if services do not exist where the family is located. I think it's important to also talk about how Alaska OCS defines active efforts. It's a little bit difficult to get a clear understanding of what they define as active efforts, but we were able to find a memorandum from OCS that defines, they provide examples for active efforts, and they mirror closely what ICWA active efforts are, such as identifying appropriate services and helping the parents to overcome barriers. And so when I reached out to my OCS friends, I asked them, what does that mean to overcome barriers? And they gave examples of providing transportation to parents to help them fill out paperwork, providing translators if parents only speak, let's say, Yupik, and they need translation efforts in English to help fill out forms, things like that. And also to assist those parents in obtaining services. Again, this mirrors ICWA. Federal ICWA is offering and employing culturally appropriate extended family preservation strategies and exploring and encouraging traditional and cultural ways of addressing the needs of the Indian child's parents and extended families. Next slide, please. So again, it's important to note that we talked about adoptive and foster care when there's a state action, and we talked about placement preferences. And it's important to note that placement preferences, as Deb mentioned before, those are dictated by tribe, and that's dictated by your tribal council, your tribal law, and states are obligated to follow those placement preferences when they are in place. And so when we talk about adoptive and foster care placement preferences, if your tribe has not determined or doesn't have an outline for their placement preferences, please reach out to ABCP, who will be more than happy to help you with that, because it's important that if there is an Indian child that's taken into custody, that the placement preferences for adoptive and foster care are going to be followed. And generally, we see that the tribe's placement preferences may be a member of the extended family, a member of anyone in the tribe, and just going down the line, making sure that we are keeping that cultural connection to the tribe and to their culture, even when we have a state taking action and removing custody from the parents. We want to make sure that they're following our tribal placement preferences. And again, as you see on the screen, that ICWA requires that it's mandatory to follow a tribe's placement preferences unless there is good cause to deviate. And so you see the note there that tribe can have different placement preference order. One tribe can have a different placement preference than their neighboring tribe, and so on and so forth. And so I want to pause there and see if any of my co-presenters have anything to add about placement preferences. Okay, then let's move on to the next slide, please, and I'm going to pass it back over to Kevin.
Hey, thanks, Rick. So now we're going to be talking about, the substantive rights of the child, tribe, and parents. So your tribe can and should always intervene in every ICWA case. And then in addition to always intervening, you have the right to request a transfer of jurisdiction. So this is if you want to take jurisdiction of the case into your tribal court, where your tribal judges are making the placement and adoptive decisions. So this would be removing it essentially from state court and making this a tribal court case. This transfer to tribal court can happen if it's requested by the parent, Indian custodian, or by the tribe. So the tribe can request this transfer of jurisdiction. And the Indian Child Welfare Act law says that the state courts, in absence of good cause, must transfer the case to the tribal court if the tribal court requests it. So this is, if you put in the request, it's mandatory unless the state determines there's good cause. Also, the tribe could decline jurisdiction, or the parents could object to that transfer of jurisdiction as well. So this basically gives the tribe the option of whether you want to request the transfer. If it's the parent that requests the transfer, you have the option to decline the jurisdiction or to accept it. Either parent could also object to a transfer under the Indian Child Welfare Act. The only way the state can deny the transfer is if they determine that there's good cause. Now, there are some reasons that are listed as good cause, but generally the states have tried to argue good cause as kind of a catch-all, that if they don't want to transfer jurisdiction, they claim good cause. There is actually statutory definitions of good cause. I'm not going to read through all of them here, but most of them are things like, if you don't have a tribal court, that's good cause. But yet we know your tribal council is your tribal court, so we shouldn't see that happening. The child's over 12 years old and objects to the transfer is another reason the state could decline transfer. If evidence couldn't be presented in tribal court adequately, we've heard this before, but I have to say, especially now in the time of COVID, all of our state court proceedings are by distance. We can move evidence as easily in state court through tribal court as we need to. So the point of this good transfer of jurisdiction is this really is the tribe's option to have this case brought into tribal court, removed from state court and become a tribal court case, if that's what you want to do, and if you're able to provide the services to the child, to the family, to make sure that that child's being taken care of. And I'll see if anybody else has anything else to add.
I do want to add, I'm sorry, go ahead.
No, I was gonna say, kind of expand upon that point about services a little bit, in that if the child or the parent is receiving any services as part of that custody, whether that's educational, whether that's counseling, whether that's alcohol, drug, addiction services, all of the responsibility for those services goes on to the tribe. So once that transfer happens, the tribe is entirely responsible for providing those. The state no longer has any obligation to provide those services to either the children or the parents once that transfer has been completed.
Thanks, Josh. And I just want to take a second to introduce Josh. I actually asked two of the ANJC attorneys who specialize in China ICWA cases to be here with me in case there were some questions that I wasn't too comfortable asking. So Josh is one of our attorneys at ANJC, and I appreciate you joining us today, Josh. And Denise, I'm sorry, I didn't mean to cut you off.
Hello?
Hi.
Yeah, you guys were going so fast, excuse me. But I wanted to ask because this is Zita Chikiga from Malaknak, and I work as a tribal court administrator. And I wanted to know, because our tribe accepts dual enrollment, and Catholic tribe does not accept dual enrollment. Now, if we have children, and correct me if I'm wrong, if we have children that are under OCS case and or requesting under the tribal courts, the people that can intervene are the applicants that applied for first. Is that correct?
And I'm gonna actually maybe ask Winter or Josh or Chad to find out about which intervening tribe can intervene if a tribe. I think there's two, right? The eligible for membership or the currently enrolled membership. And I think that either tribe can intervene, but I want to make sure I'm correct on that.
Okay, now, some of these parents enroll their children into 2 tribes. Unknowingly, this dual membership, I know we do accept that, but I know Catholic doesn't and another community doesn't.
Right.
Now, in order to intervene, which tribe would be able to intervene on behalf of the children? Because I can be a grandparent from here, or they can be a grandparent from no, not grandparents, the parents from here and the parent from Catholic. I'm just using that as an example.
Sure, and I think this
is can intervene.
Yep, and I think this is a great question. I want to first start off by saying that tribal enrollment is going to be determined by tribal law. So if Alukkanuk has a tribal enrollment law that's different than Kotlik, that's fine. Your tribe is going to determine how your enrollment is determined. And so, but I think under ICWA and Josh or Chad or Winter or Deb or Kevin, correct me if I'm wrong, I think that it's either the tribe where the child is currently enrolled or the tribe where the child is eligible to be enrolled in that can intervene in a case.
It's the first tribe to file. Go ahead. Yeah. It's the first tribe to file. It's any eligible tribe that files. There's essentially one tribal slot at the table, and the first eligible tribe that shows up and files the paperwork is the tribe of record.
I agree with that, but I have seen disputes on this. So let's say the father's tribe, let's say the child's enrolled in Alukkanuk, but the dad's from Amonic, and so then the Amonic files the intervention, and then Alukkanuk says, no, the children are enrolled with us, then they file for their notice of intervention, and then the judge has to determine which one actually has that slot. But in that case where there was a dispute, the judge let both tribes participate, but there was one that was like the actual party of intervention, and then the other one was was still considered a party, but not the tribal intervention. It was like I forget how they determined. I think they called it like tribal community party. So it was totally not to the book. So I've never seen that before, but usually there's not a dispute. And so I agree with Joshua about that it usually is the first that files, but it can change if the tribe that filed doesn't actually have the children enrolled. The other tribe can make a case that they're the proper intervention tribe.
Well, and I would add to that let's assume that the child may even be enrolled in 2 tribes. So as far the status of when there's a dispute between tribes, and again, the first thing we say at ANJC to tribal clients is you should try to work everything out. Going to state court is like the last option. But when there are 2 tribes that could otherwise intervene under ICWA, that's going to be certainly a factor. But if it's a dispute in state court, they're going to look typically at which tribe has had the most contact with the child and the family. So, and again, you don't want to be there if you don't have to, but if they're both, if the child's eligible or enrolled in both, so it would be a potentially appropriate intervening tribes. Each tribe could intervene, then that state court's going to have to make the call, and that's just one factor in the decision making at that point. But again, you don't want to be there as tribes. You want to work it out, and many courts, in fact, probably just about all courts, will allow we'll call it a secondary tribe to sit in, to listen to the proceedings, even to speak, to say what some of their thoughts. So it can be a very friendly process, even with 2 tribes involved, depending on the jurisdiction.
Awesome. Thanks so much, Chad. And I think Deb had her hand up, and then Kevin.
Yeah, I think Chad said most of what I was going to say, and it's nice to meet both Joshua and Chad. Oh, Chad, I think I've met you before. So I think it's absolutely, and this would be my advice to all of the tribes, especially if you have neighboring tribes with eligibility or cross citizenship roles, is to work out who's going to be the primary tribe for the child before you go and approach the state court. I think it's always beneficial to the child and to the tribe to not leave it up to the state court to decide who that child's tribe should be. But it should be, and this is what Chad was saying, it should really be a decision that is made by the tribes. And the only way you can do that is not to fight it out in state court, but to talk about it tribe to tribe, whether it's through your ICWA workers or through your tribal councils. Do it tribe to tribe. And I'm saying this because we have some really bad state court decisions and some even worse federal court decisions or state court decisions that went to federal court, where they are making decisions for the tribes, and that's just bad stuff. That's, I mean, and I'm trying to be really polite in my language, but it's just bad. And we want to avoid that if at all possible. So, and this is where your tribal attorneys, your attorneys over at ABCP or at Alaska Native Justice Center or Alaska Legal Services or any number of places can give you some advice, and I really encourage tribes to call for legal advice on how to proceed if you find yourself in that kind of situation.
I have another question. Hello?
Hi, Zita, go ahead, ask your.
Yeah, I'm sorry. I didn't know if I was muted or not. The other question regarding the active efforts, because you guys were going so fast, and anyways, when the parents have active efforts, they're meeting, they're getting their meeting with their service providers. Now, when you don't have a social worker who is, like we have one case where the under OCS, the clock is ticking, and it will eventually go to losing their parental rights. But when they're doing their active efforts and this case has continued social worker overturned, I wish that clock could quit ticking. How can we help this family? Because they're trying, they're making active efforts. I hope you understand my question.
I do, and I want to start off by clarifying the active efforts term. The active efforts is really only used on the side in the state of Alaska. It's going to be used for the OCS, the Office of Children's Services. They're required to make active efforts with the Indian child, the parents, and really either reunifying or keeping the Indian child with the family. I think what you're talking about is, and correct me if I'm wrong, I think you're mentioning there may be a case plan in place and the parents are trying to comply with the case plan and really working with either tribal social services or the external social services department to really meet the requirements of the case plan. Does that sound about right?
No, these are cases that are based out of the village. And even though the parents are making active efforts with services, the problem is their social worker there's an overturn of the social worker where we don't even know where the case is at. So, you know, because the state, they use everything against you, against the parents. Now the tribe, what can we do as, in this case, to stand on behalf, and we know that they are making an effort to become healthy again and be reunited with their children. How can we as a tribe stand on behalf of that and make the judge know about that?
Yes, Thank you. And I think Deb is going to respond to your question.
So, you know, that's an excellent question. And the best course of action is for the tribal caseworker or ICWA worker, whatever title you have on your tribal worker, is to really keep great notes. Sometimes just daily journals of what the state caseworker is doing or not doing, how many staff turnovers there have been, and what the parents have been able to do or their efforts. And sometimes the parents' efforts are actually going to remedying whatever problems they're having. But they don't always match exactly the right words that are used in the state court case plan. So it's important to keep good records. And then I just want to follow up on what Rick was saying, is that the requirement for active efforts in ICWA is for the state. The state has to make active efforts to assist the parents to correct their behavior. And that can be done in not just driving them to appointments, but really helping to make sure that appointments are made, that treatment facilities are identified, and help the parents actually get into treatment in whatever way is possible, to make sure that contact between the parent and the children is happening, whether it be through supervised visits or visits at relatives' homes, etc. So the active efforts requirement is on the state caseworker, and it's the parent's job to do what they need to do to work the case plan. And I really like your idea, and maybe all of us can maybe steal this idea. It's great. Is request a stopping the clock when there's a staff turnover, because the State Office of Children's Services has an incredible staff turnover, and if the clock can stop, that would be great. Now, that would have to be worked into statute, I'm sure, technically, but I still think that it's not the parents' fault that there's been interruption in services by the state because of staff turnover, but often they are the ones who are penalized for not doing certain things. So that's a great idea.
So the parents are getting penalized for the social worker not showing up or doing his part. But yes, we do educate that we keep very good case notes on these families. And also we encourage the parents, every time you contact OCS and you, whatever message you left, you document that. That's your log history, that you were trying to keep in touch with them, but they didn't keep in touch with you. Thank you.
Thank you. And
if I might add very quickly to that, what you do too is you go to, every time there's a court hearing, the tribe shows up and says there have not been active efforts, and then the tribe may well say, and it's gone on for 4 months, 5 months, whatever it is, and we'd like a finding of no active efforts, and we want to be clear that for any period that there is no active efforts, that doesn't get counted in that 15 out of 22 months that the state has to reach permanency or they move towards adoption. So you make a record. Also, another good tactic is to get your excellent notes and things to the parent's defense lawyer. And sometimes you've got to push those folks. They're very busy too, and say, hey, this isn't happening. We need these referrals. We need transportation. These are the things we, the tribe, believe the parents need. We're doing what we can. We're not the social workers. Of course, at the end of the day, you know, time is still problematic if the parents can't see their kids and can't bond and all those things. So if it's really crucial and just things are really not moving, filing a motion, getting a hearing is the way to force that along. And again, you may do that through the parents' attorneys, or as mentioned, there are a few of us organizations who do represent tribes as well that can do that. So some other thoughts on making sure those active efforts are met.
Thanks so much, Chad.
Sorry,
go ahead, Denise.
I did want to hop in and say Nastasha had dropped in the chat a reminder that if you have a tribal court and an ICWA worker, to make sure that both are communicating with each other, especially if the parent is speaking to one and not the other. So if they're speaking with the tribal court and not the ICWA worker, or the ICWA worker and not the tribal court, in asking the tribe to take jurisdiction. So I just wanted to make sure that that comment was there, and I did see that Nastasha did have her hand raised.
Thank you. One thing that what Chad was talking about, when there's a period of constant turnover, a lot of times all the parties, whether it's the tribe, the parents' attorneys, the guardian ad litem, a lot of times we can see that, and all the parties other than OCS can, file a motion regarding a certain period of time with no active efforts. And usually the state doesn't want to go to court to have contested active efforts hearings. So usually the parties are able to negotiate with the state to figure out how many months sometimes there was no active efforts. And especially if your tribe is compacted with ABCP, usually we have an attorney that represents the tribe. So, that's the one thing that, especially if you're compacted with ABCP, finding out who the tribe's attorney is and, discussing this with them, having case staffing, always having communication, keeping everybody in the loop. Your ICWA worker that is there in the village is basically the point of contact for the advocate and the tribe's attorney to go through, whichever entity is the one making the decisions for the case. That's all I want to say.
Thanks so much, Nastasia. And that was a great conversation with lots of great answers and questions. So thank you for that. Does anybody else have any questions before we move on? Okay, so I think that we are back to Winter. On the next slide, please.
All right, so how does ICWA affect a China case? So we've already talked about intervention. We had a great discussion about that. So basically, the tribe has the right to be there as a party, and that's in a practical matter. You file the notice of intervention. If you're compacted with ABCP or another organization, then the attorney for the tribe will file that. If you're not compacted, then your tribe will file that notice. Once you file the notice of intervention, then you become a party, and then you get served all the filings so you know when the hearings will be. The placement preferences are different. So that's basically when a child's been removed from the home and placed in a foster home. So there's informal ways to get a Native child in a Native home or a Native home that's also a relative. So the informal way is to email the OCS worker and the AG and CC the other parties in the case and say, we have this family, they're the child's maternal grandmother. We believe it's a safe home. This is their contact information. We believe the children should be moved here. It's in their home village. And so you can do that informally. Then OCS will look at the information, and they're supposed to call and see if this is a better placement than maybe the non-relative foster home or wherever the child is located. So if that doesn't work, then there's a formal way, which is you would file for hearing on placement. And at that time is going back to what Mr. Hull and other people had said about keeping good notes and bringing your information forward to the court. And then this is when you say, on this date, I sent this email with a list of preferences of the child's relatives, and we received no response from OCS. That was 45 days ago. Now we want put the caseworker on the stand and ask them questions. Have you made these phone calls? Have you checked in with these family? Why are they not suitable? Why aren't the children been moved to this family? So the best way, I think, is you try to do it informally, but if that doesn't work, OCS, as we talked about, the turnover and the change of caseworkers, maybe they haven't got around to it. So once they see the notice of hearing, they actually, sometimes they'll do nothing, and then all of a sudden the hearing's coming up. And I've seen where actually we get to the hearing and then the OCS stands up and says, hey, can we vacate the hearing because we put the children with where the tribe wanted us to put the child. Okay, well, I guess, we don't need to have this hearing, or we can have a quick hearing and they can put on the record their efforts to move the children to the placement, which had the highest preference. So it's a good practice to, again, try to do it informally. If not, then go towards the hearing, and it might inspire OCS to start moving a little bit faster when they see they're going to have to face the judge and the other parties and be questioned about their efforts to bring the children to a relative placement. Rick already talked a lot about active efforts, but basically in a regular case that ICWA didn't apply, then the state just has to do reasonable efforts to reunite the family. In cases where ICWA applies, that's a higher standard, active efforts, and that's the state has to make the active efforts to reunify the family or to keep the family together. So always be keeping notes and keeping the state reminded of their obligations. And it is disappointing at times because you could go to the hearing, and as Mr. Holt said, you could get that finding from the judge that they haven't made active efforts, but it doesn't, I think in some of our minds, okay, well, we won the hearing. Do the kids get to go back home to their parents since the state's not doing anything? No, usually it's just if they don't get their active efforts finding, everything stays the status quo. There'll just be another hearing within 30 or 60 days to relook at active efforts. So, but it does put pressure on them that they need to start doing their obligations to bring the family together. And then there's other like funding that the state gets when they get their findings for active efforts, so that there is another incentive for them to, if they're not getting the findings in their cases, then they're going to be getting less money. So that causes some issues with the state too. So that's something in the back of their mind. But at the end of the day, it's about getting the children with their family, and there's different ways to put pressure on the state to do that. But it always goes back to just trying to get the family back together and holding the state accountable.
Awesome.
Right, I think
Thanks, Winter.
Thanks,
Winter. Next slide, please. So we've talked a lot about China cases, and so I just wanted to kind of highlight the parties to a China case, which of course implicate ICWA. There are many parties. I know that if any of us have been in a China case in a courtroom, you're seeing a lot of people there. So this slide highlights details who is involved. So of course we have the state of Alaska, the Office of Children's Services, and they have the legal custody of child, and they're normally going to be represented there by a social worker. There's the Attorney General for the state of Alaska. They're going to be the attorneys for OCS, and it's normally represented by an assistant attorney general. There's a guardian ad litem that's normally appointed, and that guardian ad litem's responsibilities are really to advocate for the best interest of the child. The parents will also have an attorney appointed for them if they can't afford one. So the parents' attorneys as well as the parents are going to be parties to that kind of case. In certain situations, if the child is old enough, the guardian line can advocate and can request that the child have their own separate attorney appointed for them. So you may see an attorney for the child. And then you're going to see the tribe, or the tribal ICWA worker, family services worker, social services worker. And so I think it's really important to note, since we are talking about this from the tribal aspect, that in a China case, that the tribe is the only party that is not appointed or not eligible for the appointment of an attorney in a China case. So that's where resources such as, you know, the ICWA department within ABCP and their relationship with Alaska Legal Services comes into play. And other Native nonprofit and nonprofit organizations throughout the state that assist tribes in representing them in ICWA cases come into play. Next slide, please. And I'm going to pass it back over to Winter.
All right, thanks, Rick. So I'm just going to walk through some of the main hearings that if you've intervened at the tribe that you'll encounter. So the first hearing is called, so if it's a non-emergency petition, it's usually just a probable cause hearing, and that's the state, whether it's more probable or not that one of the subsections, that's what Denise listed off, has there been neglect, has there been sexual abuse, has there been a runaway child, is it more probable not that this occurred? In an emergency petition, it'll be a probable cause and removal hearing, and that's where the state has to prove that it's more probable or not that this occurred, and that removal is necessary to prevent imminent harm to the child. Expert has been qualified in a specified area that the children need to be removed because of the risk of high risk of emotional damage to the child. So that's going to happen. The emergency hearing is going to be within 48 hours of the children being taken, or if it's a non-emergency petition, it's usually going to be within 30 days of the state getting involved. The adjudication hearing comes 120 days, or it's supposed to. We talked about the turnover of the caseworkers and stuff, so it's supposed to be 120 days from the finding of probable cause. At the adjudication hearing, then the standard goes up. It's a preponderance of evidence to determine whether the child has been abused or not abused. After that finding, then it goes to disposition. That's usually 90 days from the adjudication hearing. At disposition is the finding about active efforts. If there have not been active, if the judge finds there has not been active efforts, then the disposition hearing, the judge can't enter findings. And as I talked about before, does it mean the children go home or the case is dismissed? No, it just means that the state needs to get their act together, go back and do the efforts, and then the disposition hearing will be set on for a later time. And that's the hearing where the ICWA workers are so important, and all their notes about what the state has done and what they haven't done, as well as the parents' attorneys and then the tribe's attorney, or the tribe if you're representing yourself. So the permanency hearing that happens every year, that's basically the hearing where what is the plan for the children? How are we working towards that plan? So if it's an older, maybe it was a runaway that was 16, how are we giving them services to keep them in the home, keep them safe? Are we going to help them apply to, if they've dropped out of school, to get their GED, to help them get job training? So kind of like that's a plan for maybe an older child. Another plan could be the parents had a substance abuse issue and they went to treatment and they were working really hard and they're doing great. So the plan is that if they continue to stay sober and stay on their safety and treatment plan, then the children will be returned to them within the next 30 days. That could be another plan for permanency. So it's basically, are the children going to go back home? Are they going to be adopted? Are they going to have a guardianship? So that's just going through what the plan is for the children. Oh, and then I was going to add, at any time, any stage, as we talked about before, the case can get transferred to tribal jurisdiction. So a tribe might intervene at probable cause. Okay, well, the state's going to be taking taking custody, but we're going to be a party and intervene. But anytime during the case, let's say it comes to adjudication or disposition and the state's not doing active efforts and the tribal court thinks, you know, we've intervened, we've been part of this case. We believe that we should take jurisdiction, transfer the case to tribal jurisdiction because it doesn't seem like the state has their act together, or we just have this new treatment plan at our tribal court that we think fits perfect with the parents, and we think that we could get reunification faster. So at any time, you can request that the case be taken out of state court and brought to tribal jurisdiction. So I think there has to be good cause or an objection by parent or for it not to go. I've only seen the state object when it's getting close to termination. So when maybe the case has been going on for a couple years, the state files a termination petition and they're kind of pushing towards adoption, and then the tribe seeks jurisdiction. I've seen them object for good cause, the good cause being having a permanent plan for the children and that the case has drug on for so long. So that could be a way that they object, but just know, even if you got that up to termination, probable cause all the way to termination, you can seek to have the case brought to tribal court, and you can explain to the judge why at that time you think it's best for the case to go to tribal jurisdiction. You know, a lot of the tribal courts have been building up and getting more and more cases. So you could tell the judge, yeah, maybe it's termination right now, but 2 years ago, we didn't have the resources to serve this family, but now we do. So you definitely can make those arguments to get the case to your court.
Awesome. Thanks, Minter. And I think we're going to move to Deb for the next slide, please.
Okay, throughout all of this, from the very beginning, when the petition has been filed with the state court, in the petition, and this goes back to, I think, the slide that Denise showed, there is the whole list of abuse and neglect issues that define child abuse or neglect. And one of those, or a combination of those, child abuse offenses or issues need to be alleged or charged in the original petition. And I bring this back, I go back to the very beginning of this case for a reason, because in the case plan, and so after what Winter just said, after the probable cause hearing, after the adjudication, which is the trial that proves whether or not what issues the petition raises have actually occurred or not. Has there been a harm of some kind, or is there a risk of harm to the child? It's either proven or not proven. And often there's more than one thing that has been charged. And so say that it has been proven, those behaviors that have led to the harm or the risk of harm to the child by the parents then need to be remedied somehow. And that is where the case plan comes from. So let's say that the parent or parents are drinking a lot, and because of their drinking, they're being neglectful. There's not enough food in the house, they're not able to keep the lights on, or they have left the children unsupervised, or all of those things. And at the trial stage, or otherwise known as the adjudication, though that offense or that claim has been proven. So the case plan then becomes some kind of a treatment or services to the parents to be able to address that alcohol abuse issue. Now, the offense might be drugs, it might be alcohol, it might be something else, or it might be lack of parenting. So the case plan must then go to that. So if the case plan is the way it should be, it is only addressing those things. And the case plan actually comes fairly soon after the trial phase, and should should be very narrowly defined and should only address the things that have been proven. Now, as the case goes on, and I am almost positive everybody in this virtual room has seen that when children are in state care for too long or for a long time, what happens is the caseworker, as they get to know the family, starts seeing other things that might be coming up, lack of parenting, or they might see drug use, or even, and I'll go as far as saying they might see physical abuse. But if that has not been alleged and then brought to trial to prove or not prove, it should not be in the case plan. And now this might be a controversial issue because we're all about keeping our children safe and our safe from harm and risk of harm. But the parents also have a right to not be accused of things without being given an opportunity to defend themselves. So if during the course of providing services to the family, both parents and children, something else comes up, then it really needs to be brought back up to the court and adjudicated or brought up. Now, often the parents can also be given an opportunity to say, yes, I have an anger problem, and yes, I'm using physical, I'm causing physical injury, and they may voluntarily agree to do that, but it can't be court ordered. They can voluntarily go to an anger management or a domestic violence intervention program of some kind, but again, it is voluntary at that point. Now, what this does by keeping an eye on what was alleged, what's in the case plan, and then the parents' progress on that, as the tribe and the ICWA worker, you can keep an eye on that and start making your own case notes and reports to the state court about the progress that's being made by the parents to remedy the situation that caused this family to come into care in the state court in the first place. And that's very important. And it prevents required services from continually being added to the case plan without a basis, without a foundation, because those kinds of cases tend to go on forever and ever and never stop. And then the state, of course, has a 2-year time limit for children to be kept in care before adoption and or termination of parental rights kicks in by statute. The state has to do that, and then the tribe runs the risk of losing those children to adoption completely. And so that's one of the protections of ICWA, is to, again, pay attention to that case plan and make sure that the services that are being offered go to what's there. And I'll tell you, the state has a lot of problems and a lot of issues. The Office of Children's Services has, their budget continually get cut. Their supervision of caseworkers is not always the best in some areas. It's inconsistent. So the tribal workers, of course, can jump in and offer to provide some services that go to helping make return home safer or safe for the children. And at the beginning of at the adjudication stage or the trial stage, the tribe can also come in and offer its own case plan along with what you think the state should be able to do or services offered, and what the tribe might be able to do, so that it becomes then both the tribe and the state providing services to the family. And it could be services to the children and or services to the parents. And that could include a lot of things, and some of them are listed here in this. It could be mental health, drug and alcohol treatment, parenting classes, domestic violence services for both the person who has been a victim of domestic violence or sexual assault and that person who's been committing the violence. Could be sexual assault or violence counseling for the children who have witnessed it or been a victim to it. It could be any number of types of services. So, and it's something that you want to monitor all the time, even between hearings. And speaking as a judge who has been both in state court and in tribal court, the state court hearings, review hearings, and all of the hearings that Winter just went through seem to be many, many, many months apart. And the tribal court has an opportunity, and usually because it's a smaller caseload, a much better opportunity of having more frequent hearings for the families that help to keep the parents on task. Now, you only get that if you actually transfer the case over to tribal court, and you can only do that if you have certain things in place. So my advice is to stay in touch with the caseworker, and if your tribe has services that it can provide to the family, even if it's only one member of the family, I encourage you to do that and make sure that written reports are being provided to the court at the hearings. And even before the hearings, you can always file a report with the court, and then they'll read it and have it in front of them at the next hearing. So I know Estelle was having some trouble getting on, so I'm not sure if she had anything to add. And I also know we're starting to run out of time. But
so yeah, we were I was just going to jump on quickly and let everybody know that we are likely going to go over, and that our sessions are recorded and they will be up on the ABCP website once we're able to get them uploaded. So just know that.
Awesome. Thanks, Denise. Thanks, Deb. So I think we can move on to the next slide. Estelle, do you have anything to add to this? Okay. So I wanted to just kind of end the presentation talking about tribal child protection. And I think it's important. We've been talking a lot about ICWA. We've been talking a lot about China cases and how ICWA applies in China cases when, of course, there's a state action or a state taking of a child away from the parent's custody. And so I wanted to really draw a distinction when we talk about tribal child protection. And so I think it's important to note that there is nothing, and you see the quote on your screen, there's nothing in ICWA that prohibits or limits tribes from passing laws that would allow the tribe to initiate tribal child protection cases in tribal courts. And in fact, that tribes do retain that concurrent jurisdiction to legislate, to initiate, and to really hear. This quote is from an Alaska Supreme Court case. Of course, it's going to say China cases in there, but to really hear tribal child protection cases in tribal court. Next slide, please. So when we talk about tribal child protection cases, we're also talking about tribal adoptions. And when we talk about tribal adoptions, tribes in Alaska have been doing adoptions for centuries. And so we know that tribal adoptions are entitled to full faith and credit. And in Alaska, the Health Analytics and Vital Records, or formerly the Bureau of Vital Statistics, is required to issue a new birth certificate once an adoption order is forwarded to BVS. And then the last slide, we're talking about tribal child custody cases. And so this falls under the umbrella, again, of tribal child protection cases. I think Deb, Winter, and Kevin have all done a great job of really delineating tribal child protection cases. And so that is really just child custody cases. That is where the tribal court is being asked to settle custody disputes between parents. And so there's no state action that's being taken, and therefore there is no ICWA implications or requirements in tribal court. The final thing I want to mention is that John V. Baker recognized that Alaska tribes have clear jurisdiction over custody disputes between parents of tribal children. So I know that we kind of went through the last 3 slides very quickly, and I just wanted to make sure that we're drawing that distinction between state-involved China cases and tribal child protection cases. In a state China case where there has been state action or state taking of a child, ICWA will apply. In a tribal child protection case, ICWA will never apply in tribal courts unless your tribe has adopted ICWA in full or in part. And then we can move to the last slide. And that is, does anybody have any questions? I know this is a long session. I think this was a great session. I'm so thankful for the co-presenters and for Josh and Chad and Winter to be here to give that attorney state side perspective. I think it was an important perspective, and they gave us a lot of great information about not only China cases in state court, but about their experiences. So I want to kind of open the floor up for questions, and I'm going to turn it back over to Denise.
So I just want to remind everybody to unmute yourself. If you're on the phone, press *6 and the little prompt will tell you that you're unmuted. If you're on the computer, there's the microphone button at the top right-hand area of your screen. So just double checking again. You could also place those questions into chat if you would like. But just opening the floor for questions or comments to any of our presenters today. Just making sure we have enough time. I don't want anybody to feel like they don't have enough time to unmute themselves. If you would like to reach out to any of us, feel free to do so. I've dropped my information in the chat, but as always, the email address for Tribal Justice is tribal-justice@avcp.org, or our phone number is 907-543-8550. You could reach out to us at any time. We welcome any questions, or, if you need help with anything. I just wanted to take the time now to thank all of our presenters and all of our participants for joining us today. It was a really great session. It was wonderful to have all the questions and the commentary and everything. It was a lot of information. Like I said, feel free to reach out to us at any time. With that being said, we look forward to meeting you next week on Tuesday at 2 p.m. for session 8, in which we will talk about tribal court orders and registering them in state court with Clay Venitas. Thank you, everybody, for joining us.